Welcome, everyone, to another great Digital Hollywood session. I'm Peter Csathy of Creative Media, and today's session is Generative AI Law. Let's get real about copyright and guilds and all that good stuff. And this is a great panel because it's more like a roundtable. Now, in this session, we have myself and Jeffrey Bennett, who's the Chief Legal Officer of SAG-AFTRA, and we also have Avery Williams, who's a partner at McKool Smith. And so I'm going to kind of take this as a initial rundown of some of the major developments, but then we'll get into a discussion with Avery primarily on kind of the legal landscape, how it's evolving. And it won't be just exclusively Avery, Jeffrey, but kind of taking the lead there. And then we'll get into the dynamics of the SAG negotiations and the guilds, and then a lot of other stuff. But welcome, Jeffrey. Welcome, Avery. And why don't you two just give brief introductions of yourselves, because there's a lot there.
Sure, Jeffrey, go ahead.
All right, thank you, Avery. As Peter said, I'm Jeffrey Bennett, Chief Legal Officer of SAG-AFTRA. SAG-AFTRA is an entertainment union that represents over 160,000 actors, sound recording artists, broadcast journalists, influencers, podcasters, commercial performers, and audiobook narrators. I started working after law school at William Morris Endeavor, a bit of a cliche. I was in the mailroom at William Morris. And I worked in private practice after that, negotiating contracts for talent. And then I moved to SAG-AFTRA. So the takeaway, I've spent my entire career working on behalf of human, professional, creative talent. That is what I do.
Excellent. Thanks, Jeffrey. And Avery.
Hi, my name is Avery Williams. I am an attorney at McKool Smith. McKool Smith is a mid-sized boutique litigation firm. We don't have any transactional practice. We just try cases. And my practice has been intellectual property other than patent. So I don't do patent work, but I do trademark, trade secret, and lately, I'm very closely following the artificial intelligence copyright litigation that's working its way through the courts.
Excellent. Thanks, guys. And I've been fortunate to work pretty closely with both of you. And for everybody out there, it doesn't get any better in terms of the expertise on the topics that we're talking about. So that's great. I'm going to take through just a couple of the developments as kind of high level, 60,000 foot of the context, and then we'll get into more of the detail. But just now on the copyright infringement front, by the sources that I have, we have over 125 copyright infringement cases related to AI on a global basis. So there's no stopping, despite the fact that there are some settlements, some resolution that's going on amongst business, the business players in this world of AI as it meets entertainment and media. Nonetheless, the copyright litigation continues to proliferate. We also, of course, we have the new guild agreement that Jeffrey's going to discuss and the dynamics behind that. So that will be interesting to get into, replicas versus synthetics and the human side of it all, and how SAG and Jeffrey feel about or can convey how the creative community is thinking about it all. And then we have, yes, with all the pressure of this proliferation of litigation, we have I would say an accelerating pace of settlements amongst players. So the biggest one that has happened in the copyright infringement context is the Anthropic settlement with the Writers Guild. It wasn't with the Writers Guild. It was with the Author Guild and all the writers related to that. And that was a $1.5 billion settlement, which sounds great in theory, but when you look at the $7 trillion that McKinsey is saying that the AI players are going to be investing in infrastructure, it's a drop in the bucket. So, from my perspective, don't let that headline fool you. That's the case. Then there are significant licensing deals that have started to happen, kind of a trickle, I would say, but it's increasing. The biggest one that I've seen is Disney licensing its beloved Disney characters to OpenAI for its Sora, which is the video generator. And that was a huge deal. That was a very huge deal. That was, big fanfare just, 7 months ago, something like that. And then 3 months later, OpenAI shut down Sora. So it was all for naught, but you guys will have more perspective on that. Then you have even boutique firms, like some of the most human, Jeffrey, to your point about human, and human creativity, A24 is one of the most highly pedigreed studios of humanity, and some of the best pedigreed directors and their films. And even A24, this wunderkind when it comes to creativity, now has accepted a $75 million investment by Google DeepMind. And I'm curious to get your thoughts about that, Jeffrey, too. And then one last thing, I guess, just to kind of set the stage of something I find interesting. Amazon, one of its biggest shows right now, as I understand it, is a show called House of David that stars Sir Ben Kingsley. And that is created in partnership with Wonder Project. And Wonder Project has a major AI component to it with Innovative Dreams as kind of an offshoot of Wonder Project. And they've created this very looking big budget series, but they've done it at a kind of a fraction of the cost and a fraction of the time by essentially filming the close-ups of the actors and the acting, the real humanity, in a sound studio, but everything in the background essentially is synthetic. It's artificial created. So that's a lot there to just kind of kick it up before the legal discussion. But Jeffrey, I want to give you a chance to give your flavor to any of those headline stories or others that you think should be kind of setting the stage. And then Avery, you can give your thoughts.
Sure.
Yeah, so sort of some high level thoughts about all of those issues. The first is, I will always remember that date, November 2022, when OpenAI put out ChatGPT and the world was introduced to this concept of generative artificial intelligence. Oh, look, it can write me a poem. People's first impression, that obviously and quickly evolved into images and voices and audiovisual and all of it. And of course, that also immediately brought about all of the lawsuits. The first thing that we did as a union, as we're thinking about protecting human performance, was say, we're not going to rely on the courts, and we're not going to wait around for court decisions, and we're not going to rely on Congress or wait around on Congress to deal with the issue of training of the models, what we call input. We are going to hyper-focus right now on output. What can we do to strengthen laws around voice and likeness, which is literally how our members make their living? We have to make sure state laws are as strong as they can be, our collective bargaining agreements are as strong as they can be, and in some cases reach out to some of the models and say, what kind of guardrails are you building? So you've got bargaining solutions, potentially you've got legislative solutions, you've got business-to-business solutions to get a handle on protecting human performance, protecting voice and likeness. What's interesting about the Disney deal, and I would also analogize the Universal deal with UMG or with Udio, sorry.
And by the way, for everybody out there who's listening, Udio and Suno are the two biggest AI music generative services. Anyhow, sorry, Joe.
Yep. So what was very notable about those deals, particularly Disney, they licensed what they were allowed to license, which is their IP, which is their characters. It did not include the voices, likenesses, and performances of the people who play those characters.
Right.
So it remained to be seen how effective that actually would have been on a platform, assuming it was a platform that was going to be built for fans to play around with these characters. Do you really want a character without the actual voice of the character? Is that the same experience? Who knows? It went away, but Universal was quite similar. They can license things that they own, but they don't own the voice of their artists. They can't license the voice of their artist to, say, a new platform that's going to allow for remixes or covers of songs. So again, we've been able to really focus in on those unique IP rights around voice and likeness and sort of carve out a space there to protect performers. And then finally, I'll just say the deals like A24, House of David, there were articles recently about the young George Washington movie that used similar sort of AI technology. If that technology is used to enhance and assist in pre-production or production or post-production, the way technology tools have been evolving for years to assist filmmakers, we generally don't have a problem with it. What we don't want to see, obviously, is replacing the human performers. And so far, we haven't seen that, at least not from the traditional studios and streamers that we work with. I know it's happening out there in the world. We'll probably get to that later on in the conversation. I'll talk about my thoughts about synthetic content that includes performance that is synthetic. But for now, when I read articles about A24 or any of the studios, Ben Affleck selling his company to Netflix, if those are assistive tools, if those are making visual effects even bigger and better, we don't necessarily have an issue with that because it's not touching human performance.
Just on that point, how do you feel, and how does the community that you interact with feel about tour directors like Darren Aronofsky, who have now, and even Martin Scorsese, who've embraced, for lack of a better word, AI in their, in their overall toolkit? As an example, Aronofsky has a partnership with Google, and I'm curious to get your thoughts about that. Because they are because people follow them so closely as great artists.
I think they see the inevitability of the technology in some way, shape, or form having an impact on entertainment and media. That sort of feeling about the inevitability obviously falls sort of headlong into the issues of, but how was the technology developed? How do you took arguably thousands of years, hundreds of thousands of human creative talent work to train a model that can replace human creativity. So that is sort of the umbrella that bleeds into all of these conversations. But again, unless there's a silver bullet, unless the cases all start going the right way and saying that's illegal, that's copyright infringement, and you start to unravel all of those models that are out there. Unless that happens, and I can't wait and hope that that's going to happen, I understand if filmmakers are like, let me see what this is. Let me see what it can do. Let me see if it brings value or not. And all of that's done with the understanding that there's a real issue among the creative community about how these things came about.
Yeah, absolutely. And Avery, I'm curious to get your thoughts just in terms of like setting the stage.
Yeah. So, the two biggest decisions that that have come out are, of course, the Bart's and the Kadri decisions, and they both got to the same place. They both found fair use, but for very, very different reasons. One found basically fair use because of, a very critical Judge Chabria sort of chastising the attorneys for failing to prove up market dilution. The other finding that, but saying, on the other hand, and then on the other hand, the other solution, the other case was, yes, fair use, however, not if it's pirated. So, both of you got to the fair use issue, but piracy was an entirely different finding, and that's what led to that giant settlement. So, I think at this
And that's
point,
in the Bart's versus Anthropic case
that's
that I
right.
mentioned. Yeah.
And well, and now Kadri is going to appeal to the Ninth Circuit on the issue of whether you can sort of cleanse piracy of digital media by then employing it in a way that's transformative. And we'll see what the Ninth Circuit says about that. I'm sure it'll be informative no matter which way they go, because we have two cases, the two sort of fence posts of the fair use dispute have gone, reached the same conclusion, but by very different roads. So it will be informative no matter what happens.
Yeah, and Kadri versus Meta was the language of the court was actually very favorable to the creative community, very favorable. In fact, the judge, in his opinion, laid out a roadmap for lawyers to follow, the arguments to follow, the arguments that made sense. And like you said, that's been on appeal now for a long, long time. So Avery and Jeffrey, why do you think that is? Why? And I'm curious, just as a threshold, because it's such an important decision. Does it even matter anymore because a year has gone by since then and people keep doing their thing?
Well, from a legal perspective, being on appeal for a year is not really that unusual,
Yeah.
unfortunately. But I would say that from my perspective, the length of the appeal doesn't reduce the importance of the issue. Of course, you know, those of us who feel like the rights of the creative people should be protected and should be represented in the economics of the AI issue going forward, justice delayed is in some sense justice denied. But Peter, you started this conversation by saying, the trillions of dollars that are being invested in this in this infrastructure. I think they're just going to take their time because it's such a huge question. It is
Yeah.
world-shaking level of economic investment, and they are not going to lightly go into this decision.
Yeah.
I think that's right. And Peter, when I read those cases, I try to follow all these cases, and the market replacement argument that was raised by the judge immediately got me thinking, all right, what are the cases that are out there that have the best opportunity to show that? And
Jeffrey,
for
can you
me,
explain? Because
yeah,
there are going to be a lot of people who are watching and listening to this who won't know what that means. Can you just explain that a little bit? What the market replacement, the rationale, and how it came into play and why it matters?
yeah. So the fourth factor of the fair use test, and Avery, correct me if I get this wrong, deals with market replacement of the copyrighted work that you have taken and allegedly transformed and are arguing is subject to fair use. If you are replacing the market for that copyright, you're certainly not going to win on that fourth fair use factor, and that's a pretty critical factor in the analysis of whether or not you have infringement or fair use. And the best example, the one that immediately jumped to my mind when I read the judge's words, was the record labels suing Suno and Udio, because as far as I know, both companies admitted to using all of the libraries of those record labels that were suing to train the model. And
They did.
what does the model do? Allows any user that wants to generate a 3.5 minute song. The record labels are in the business, and artists are in the business with record labels, of making 3.5 minute songs to play on streaming services and cable and radio. And so if that is not direct market replacement for the whole of the library of and the business model for labels, I don't know what is. But it's almost market replacement on a scale we've never seen. No court's ever had to analyze market replacement in that kind of a way. I was also very interested in the Disney versus Midjourney case, because as you all probably know, the studios were late to the party, which I think surprised a lot of people. Like, where are the studios? Why haven't they sued? We know their stuff is in all the models too. They decided to sue Midjourney, if you read the pleading, because Midjourney really made no effort whatsoever to put guardrails on the output. They even went so far as advertising, a Hollywood studio in your pocket, and look at the kind of stuff you can create. And they showed examples of Disney characters. So again, I thought that was a very strong sort of possibly direct infringement case, even if you don't win on the input, even if you can't win on the market replacement analysis, you have output that is clearly being marketed to people to replace what Disney does. So I'm very curious to see what happens in that case.
Yeah.
That's a good
Agreed. And by the way, just for everybody again, so we understand the context of fair use. So Avery and Jeffrey have laid out at a high level the issues of copyright infringement on the input side. So whether it's Suno or Udio taking the world of music to create its tool, its video, its audio generative, song generative tool, or any of these other models on the video side that have taken, if not the full world of content, of video content that's out there, including in copyrighted content, a massive amount of it. So there's the input side, there's the output side, and then there's something called RAG that's kind of in between that we probably won't get into too much today, but it has to do with kind of real-time data that's being used and stolen from like New York Times, breaking news, things like that. But in any event, so there's the input side of the equation, just hoovering all this stuff, vacuuming it all in. And then there's the output side of like, I think a lot of people think of it as similarity, that kind of thing. But on the input side, it is, and that's where in the court cases, so the plaintiffs They claim copyright infringement, among other things. And then fair use is a defense. So fair use has to be proven by the defendant who'd sued in a case. And that's what Jeffrey was talking about, that there's this, the market replacement, which is a factor of the fair use test. Certainly for me, and I'm a lawyer too by trade, and I follow this stuff very, very closely. It's very hard for me to understand how it could be anything but an infringement when you're taking all this, because the absolute intent is for there to be a replacement here that's an alternative to licensing the works. And I'll give you one example because, I interact in the business world a lot. I know for a fact that you have studios out there who are choosing not to license songs, as an example, because it's too expensive. That's what they say. It's just too expensive. So that licensed song that in another world, in a pre-AI time, would have led to livelihoods of that composer. Well, that's going away, guys. And so that is just a market reality. But anyhow, Avery,
here's something to think about real quick. When you think about licensing and the cost of licensing, just look at some of the deals individual artists have done with, say, publishing entities that acquire the entire catalog of one artist.
Yeah.
Bruce Springsteen, Bob Dylan. Look at the numbers in those deals and extrapolate that out to all artists. It is an insurmountable number, but it should be, because that is unbelievably valuable IP that shouldn't be used for this particular purpose, in my opinion.
Yeah. And by the way, on that point, just because I don't know if you guys know this, music catalog representation for me is a core part of what I do. So I'm almost like the banker. I represent artists. Flock of Seagulls was one of my recent cases. But to your point, the valuation for these artist catalogs is based on how the buyer can then exploit that music or commercialize that music, including licensing. And so if you take that kind of licensing income away, that the valuations for the music goes way down too. And so that also hurts the artist in terms of ultimate sale.
I'd point to two areas. One case to watch on this issue is Concord v. Anthropic. So Concord Music Group sued Anthropic, and they are sort of a live test bed right now for the market dilution theory. So that is at issue in a summary judgment pleading and is before the court. And they have done a much better job in showing market dilution because they had that guidance from the previous holding. And also because, at least from the AI songwriting point of view, you've got examples of hit songs that are trending on Spotify that it turns out that no one ever sang, no one ever wrote. So they have gathered the data and done a much better job. Chabri would be proud of gathering evidence for market dilution. In talking with some folks that are in the author space, interestingly enough, one of the biggest areas this is impacting authors is romance novels. So I didn't actually know this, but romance novels are the largest subgenre of fiction.
I don't know. Are you sure you don't read romance? Know. Yeah, come on, Avery. You seem like a romantic guy.
Yeah, romantic guy, but
we got to have a little fun here, guys.
But the point is that people who read romance novels are voracious. These folks will read 2 or 3 novels a week, and they have very, very specialized tastes, like vampire kidnapping romance novels. That might be all a person wants to read. And what AI, it turns out, is very good at is churning out a ton of content on a specific topic. So you have these folks that are, at least were making a decent living churning out vampire kidnapping romance novels because there's, across the world, 10,000 people that is the only thing they want to read. And I have heard from not only them, but their lawyers who represent these folks that they're disheartened because now when they go to post their work, they're one of 200 instead of one of 3 that people have the choice to choose from. So, I think we'll see more of these cases come, these market substitution and market dilution cases, once people understand how to gather the data, how to make it right. Political cartoonists are another issue where you have a very great track record of sales to newspapers, online and traditional print, and they've been tracking their sales for a long time, and then out comes Midjourney, and they can just see their revenue ticking down and down and down as you an elephant and a donkey go into a bar and tell a joke. You can get Midjourney to generate whatever you want. So I think we'll see more and more of it. I think we'll see some success there, at least at the trial court level. The question is how the Ninth Circuit and other circuits will sort it out, and it's just the Wild West at this point.
So what are you seeing, Avery, in terms of the primary defenses that, not fair use per se, but built in the arguments by the defendants to try to beat back these arguments? Certainly you hear the refrain of, well, this is just technology, and technology has always disrupted markets, and and people have lost jobs. Like hand-drawn animation was lost to digital animation, but overall it created more jobs and all that kind of stuff. You hear that. What else are you seeing in these cases to try to sway the courts that this is just what happens?
Yeah, I think you see a lot of that. I mean, one of my sort of ironic favorites is the Disney versus Minimax. And Minimax is arguing you can't copyright characters, which is, go ahead and tell Disney they don't have an interest in Darth Vader as a character. See how that goes for you. But on a more serious note, you certainly see the policy argument that technology has to advance and that this will generally be good for the world, because every time there's a disruptive technology, it ends up creating more jobs and not less. But I think if you look at the Copyright Office's guidance on how intellectual property rights evolve with technology, you pretty quickly get to the point where you have to recognize that the technological growth and the growth of the jobs that may be associated with it have always gone hand in hand with an adoption of intellectual property rights that supports that technology. Like when the camera first came out, right? The artists of the world all were saying this is the end of art. You'll never be able to do it. And there were people who sued the Copyright Office saying you can't copyright a photograph. It's just what they saw. And that very quickly got shot down, and intellectual property rights kept up with technology. And I have to believe that we'll see intellectual property rights continue to keep up with technology here, to the extent that job growth comes along with that. I think that these arguments that we get from the defendants in this case, from a policy point of view, are going to fall flat.
How do you feel? I know that I've seen some recent developments that defendants are using the fact that some of the plaintiffs are utilizing AI in their own for their own internal purposes. It's almost like guilt by association, or how dare you complain because you're using AI tools yourself? Have you seen that in litigation, and do you believe there's any merit to that?
Well, so there's a couple of different ways to look at it. The first is a unclean hands theory, right? The legal doctrine of unclean hands is that you can't sue me for this because you're doing the bad thing as well. Classically, not a perfect example, but an illegal contract, right? Let's say, Peter, you and I enter into, despite our best efforts, a contract for me to sell you enriched uranium, right? That contract is void as a matter of law. You can sue me for screwing you on the deal, but I can say, hey, look, you're as guilty as I am of entering into this illegal contract. You can't sue me for that. I can't sue you for that. It's not a perfect example because illegality of a contract is a slightly different doctrine, but you get the idea. Okay. I don't think that's going to work for them at all, because there is nothing illegal or about using AI with your own intellectual property. If you own the rights to something, you bargained for it, and you have permission to do it, then it's yours. Disney is free to make all the Darth Vader memes it wants with AI. They own Darth Vader. Go ahead. I think that where you get into a slightly more interesting question is if the studios, or if any creative person has used AI to create a work that they then claim copyright on. Because that is a little bit problematic, because as we can see with the cases that have worked up the Supreme Court, you cannot copyright a purely AI work. It's not copyrightable because the U.S. Copyright Code requires a person to create a copyrightable work. So there's the two levels there are, one, you can't sue me because you do it too. I don't think that's going to work at all. But you can't sue me because you used AI to create the thing you're suing me over. That might have legs. And the Copyright Office put out a really good report on the extent to which human intervention is required for an AI work before it becomes copyrightable. So, the second argument, maybe.
Okay, let me throw
Yeah.
in one third piece, and then Jeffrey. Well, Jeffrey, why don't you chime in on that one, and then because I have another one that I'd like to discuss with you guys.
Obviously, that's the other, I think, huge element here, which is copyrightability of output, as Avery noted. And we have been following the Thaler case. I actually spoke with Thaler several times. And now, I guess, the Allen case, we're waiting on a decision from the courts on the Allen case, which I think will be much more interesting than the Thaler case. The Thaler case, there was no question the machine did everything. In the Allen case, Allen is
Jeffrey,
arguing.
can you just give the facts of just really briefly so
Yeah,
people understand the context?
sure. So Dr. Thaler created what he called a paraphrasing, like the creativity machine, and he used the creativity machine to generate output, and then he tried to copyright that output to himself as the owner of the creativity machine. And that was, I think, the easiest case that the courts are going to have to handle. The next case is the Allen case, where what he is arguing is, I used, well over 600 prompts to get to the final output that I then claimed was mine. Now, I would argue, and I hope the court sees this argument and agrees, even though you had over 600 prompts, prompts are ideas. Prompts are not creative expression. So you may have had 600 different ideas about what to do, but each time it was expressed by the machine. You didn't do the expressing of the creativity. So if that holds, then I think you've got a real interesting situation when it comes to AI generated works. Who's doing the expressing? And if you can't protect it with IP, I don't see how, where's the incentive to create if you can't protect your creation, other than platforms that will say, we don't care what's on our platform, whether it's IP protected or not. We just want people to come to our platform. That's another conversation. But for IP owners and the people that are interested in IP and monetizing IP, not being able to own it is a real problem.
Yes. I mean, that's pretty wild. Just on the way you described that second case, which I wasn't even aware of that one, is that let's say you're a screenwriter and you have a couple ideas and you punch it into Anthropic, into Claude, and because you can get a draft screenplay, like right off the bat, you can. 3 act structure, et cetera. And then you just continuously fine tune it like, okay, but do this, do this, do this. So you're saying that from your perspective, that's no matter how many prompts you put in there as the screenwriter, it's not copyrightable. That should be the right result.
Yeah, I mean, the expressive elements. I mean, think about any idea, Romeo and Juliet, boy meets girl, they fall in love, boy has a tragic accident, girl commits suicide, boy's actually not, whatever the story is, I don't even remember. That's an idea.
So you're not a romantic if you don't.
I'm not.
Avery is.
I don't read the models. I don't even remember Romeo and Juliet. So don't look to me for that. But that idea, that general idea of romance, boy meets girl, something tragic happens, they get back together, whatever the case may be, those are all ideas. Someone has to express them and create the characters and describe the setting and the scene and the dialogue. Like, those are the expressive elements that if you cede that to a machine, you're not going to be able to protect that as IP.
Yeah. And then, okay, go ahead. Sorry.
Just briefly, there's a concept in copyright law called work for hire. which I think everyone on the panel is familiar with. But that's where I have an idea and I'm not capable of executing it, but I know a guy who is. So I say, hey, I want to pay you to execute my idea. It could be an author, it could be a painter, it could be any creative person. And by contract, then, that person cedes copyright rights to me. That is the bargain I have created with this person who created a thing. And because a person created the thing, copyright may vest in the creative person and then transfer to me. The problem you have with AI is there is no copyright that vests, period. There is no way for a copyright, for an AI to act as a work for hire and transfer copyright rights to me because the AI never owned a copyright in it. So this idea where I can give instruction even repetitively to an AI under current law, at least, right? And then somehow vest myself with copyrights over an expression that was never done by a person, I think is fundamentally flawed.
Okay, so now I want to get a little, I want to talk about international context a little bit too. I want to touch upon that. But first, there are, obviously a lot of people in the creative community, whether that's in entertainment or marketing, branding, et cetera. They're using these tools. They're using these tools to create, and they assume because these tools are on the market that they have a right to be able to use them. But is there a risk to them of copyright infringement by, through theories of secondary liability or vicarious liability or that? Because if Avery, if you can just kind of lay out that practical standpoint, because if you're a creative agency, as an example, and you're using a tool like Dance, then which is a video generator tool that I just wrote my latest newsletter on this was that Dance is the video generator of choice. Everybody's using it in the world of who's using AI for video generation.
So I just want to preface this by saying I'm not an expert on international copyright law. But
Oh no, not international on this, on secondary liability in the United States. So people who are a creative agency in the US that has chosen to use these tools, or a studio that has chosen to use these tools, should they be worried about any potential liability?
Yeah, so you've got there's I think two stages to that. The first is, of course, you got to talk about Cox versus Sony, right? Cox versus Sony was a case that recently came down that basically skewered secondary liability for internet hosters as being liable for piracy. The Supreme Court held that it was actually from a legal nerd point of view a very interesting discussion. The difference between doing something knowingly and doing something intentionally. The mental state required by a contributory infringer for copyright liability from a internet provider perspective is intentionally. So they have to intend that the service they provide is contributing to copyright infringement, not just knowing. Just knowing that your users are pirates, not enough. So that is having ripple effects all throughout the generative AI industry. You see people dropping claims, you see people moving for summary judgment on these secondary liability themes. Those lawsuits are targeted towards the provider. I think your question was more centered on, as a user.
Yeah, a user.
Worried. Right. So the user is, of course, everyone's liable for their own infringement. Direct infringement. So if you produce and publish a work on AI that in fact is an infringement upon someone else's IP, if you go to Midjourney and say, give me a picture of Luke Skywalker eating my hamburger, and then you put that photograph up on your billboard, boy, I guess Mark Hamill's not going to like that. You're going to get sued.
But how about if you're just because you just know in the zeitgeist that you're using a tool that is sucked in the world of copyrighted materials, and there's major litigation that shows that there's a likelihood that there's IP risk there. The mere use of that knowledge, what do you think?
No, not under the Copyright Act, right? Copyright
Okay.
Act requires copying of a copyrighted work. So you have to somehow make a copy of something that is protected by the Copyright Act. And if as a user, you're not making something that is otherwise protected intellectual property, then you're not going to be liable in copyright.
Okay. So
Now,
Peter,
right? You might not
Yeah.
know. You might not know, right? And I want to, for example, there's a little danger zone where you get into for example, the stuff. I forget the name of the system, but it'll make a podcast out of your article. It's it's a fascinating tool, and it's incredibly effective. But we see more and more voice actors complaining, "That's my voice, and you didn't pay me for it." So you might run into problems if, for example, and I know we're going to get there, the No Fakes Act comes into fruition, and all of a sudden you are using someone's voice without permission. You might be personally liable for something like that, despite the fact that you didn't even know.
Jeffrey, you wanted to add something about secondary liability?
well, I was just going to say, I think you have seen some discomfort among studios and labels, people that literally make their business an IP. There's been a little hesitation to fully embrace these tools because they know how they've been made, although you are starting to see it now. Where you're seeing a lot more of it, where there hasn't been a lot of hesitation, is in things like commercials. And that's because they're not as hyper-focused on IP in commercials. They want attention. They want to draw attention to their brand. They don't necessarily care if they own that commercial because they'll make another one and another one and another one. Where the issue is going to be for them, I think, when these tools, I say when, these tools are available all over, especially among social media sites that sort of bake them into the social media experience, you're going to see so much content. It's so easy to make content now that you are in danger of diluting your brand if you're constantly putting out synthetic stuff, if people turn against you for using synthetic stuff. I am hopeful that sort of this rise of an over sort of a flood of synthetics will make human art and sort of the authentic stuff start to rise back up to the top in ways we haven't seen in a while, because people will be like, I miss a connection. I miss that sort of experience with human creativity. Yeah, there's a million ways I could go look at entertaining synthetic stuff, even the stuff that's pretty good, but it's not the same. And you're going to sort of dilute the marketplace. Talk about market replacement. It's market dilution. It's market it's market tsunami. And so people will then want to come back and say, I want to have a relationship with the art. Who's the director? Who are these actors? Who wrote this? What's their background? Why did they write it? Like, I think you'll see sort of a resurgence of that. That's my hope.
Yeah, no, look, I'm right there with you. Christopher Nolan has that brand of people see his works because they know that everything is fully authentic and it's physical props and everything, like on grand scale. One thing I want to flag before we get into the guild issues, because we just have a very short time, is that we've been talking about copyright, and when the discussions are had in and around our communities, it's almost always for players that are almost always focused on U.S. copyright law, but there's a whole world out there. There's a whole world of complexity. And one thing I wanted to flag is that in the EU, there's a new EU act that requires transparency from the AI providers in terms of what they have trained their AI on. So like that's a very major development that's happened. Hopefully we'll see that coming in to the U.S. as well. And there's a lot of state activity going on, as Jeffrey had mentioned, in that regard. And one thing I did want to mention also, just as an example for people to understand, like let's say you're a creative agency, an AI creative agency. We talked about C-Dance as being, the chosen one at this moment in time. Well, the studios all sent cease and desist letters to C-Dance when it first launched about 6 months ago because they were clearly infringing on the output side. You could do Mickey Mouse, any one of these characters. So they put some roadblocks there, but nonetheless, that's out there. But you have, there's all kinds of, there's state laws that impact some of the distribution as well that people are going to need to deal with. So as an example, in New York, there's a new state law that requires transparency. Anytime there's an ad that has a synthetic person and a synthetic in it, that needs to be disclosed in the ad itself, as an example. So with the few minutes that we have left, Jeffrey, let's get into the guild negotiations and just give us a sneak peek behind the curtain of how it even happens. How do you begin those negotiations, and with whom, how long it takes? Just give us your background there.
Sure. And just a quick note, that New York bill was ours that deals with synthetic performers and ads, that the same bill is moving through the legislature in California. We love the idea of transparency, disclaimers, labeling, make sure consumers know. They can make the choice, but let them know, especially, let's say, music. If you're on a platform, if that is a fully AI generated song, make sure people see it prominently so they can skip it if they want to skip it. They might not want to, but they might want to. So bargaining, this can be an hour conversation. So you're testing my ability to do an elevator pitch about bargaining. We bargain with different contracts with the studios, different contracts meaning in different industries. We bargain with the studios and streamers over film and television and what that looks like, and the payment and the guardrails around how to use a performer for film and television. We also bargain with advertisers for commercials. We bargain with record labels over artists and singers. It's a lengthy process. We usually start working months and months in advance. We talk to all of our members. What are you hearing? What are you seeing? What do you want to see in this new contract? We've been negotiating these contracts in the case of film and TV for like 100 years, almost 100 years. So it's like a book. It's like the IRS code. It's a thick book. We constantly take some things out, add some things. And starting in 2023, we really hyper-focused on digital replication because that was a thing. That became a thing. You can now replicate somebody's voice or their likeness and have them perform. That's a direct sort of existential threat to our membership. We said to the studios, look, this is a technology. You're probably going to want to use it. You might want to use it to fix things, help things, deal with mistakes in post-production, whatever the case may be. So let's talk about it. Let's talk about what that's going to look like. Let's talk about getting informed consent. That's probably the most important piece of the puzzle. If you're going to do it, you need to talk to the person and say, here's exactly what we want to do. Do you consent to that? Not do you consent to digital replication? No. Do you consent to a digital replica of you because we have the scene that we shot and there were mistakes and we need to fix them? This is how we're going to fix them. Are you okay with that using digital replica technology? We wanted to see the specificity so that people could say, okay, I see what you're doing. I'm okay with that. That, I think, gives us a lot of comfort. And then payment. We wanted to make sure people aren't paid. This isn't a way to get around paying people. If you use a digital replica, you still got to pay them as if they performed in person. So we didn't want to see an economic benefit for digital replication. So that was a focus of ours in the 2023 round of bargaining with the studios. We did the same thing with the labels. We did the same thing with the advertisers. We did the same thing in podcasts. We did the same thing in audiobooks. We're building sort of guardrails around replicas. I kind of joke, and I shouldn't, with our members, like that may have been the easy part of what we're going to have to do. Because now what we're going to have to do is deal with synthetics. We have to deal with the fact that they exist, that people are making them outside of our collective bargaining agreement relationships. They're making them in other countries. We have to deal with that. And we knew that the studios would probably say, you can't just ban us from using a technology. So how do we address that? How do we address this concept of synthetics? We said, there's a commitment from both parties to prioritize and use human performers all the time, including background performers. Like you can't replace background performers with synthetics. That's in the contract. If for some reason you wanted to use a synthetic, there has to be significant additional value brought to the project, and it can't be something a human or a digital replica could do. Now, I challenge anybody to tell me what a synthetic could do that a digital replica can't do, because it's almost the same technology. It allows you to do something without the physical presence of a human, but you're using a human's voice or likeness to do it as opposed to a synthetic. So that was a way to put guardrails around it.
Jeffrey, can I ask you on that guardrail on synthetics? There are agencies out there who are, now they are creating ads with just purely synthetic. So no, no resemblance to anybody, no, not based on anybody. Does what you just said also impact the marketing world?
Absolutely, it does. And we negotiate with a group of advertisers, but not all the advertisers.
Mm-hmm.
So the people that you see doing this are probably not bargaining parties to the SAG-AFTRA agreement. They're the ones creating synthetics. And one of the way that we try to address things that happen outside of our contracts is with legislation. And that's why we said, well, at a bare minimum, let's have something in the law that says if you're using synthetics, especially if it's meant to be a doctor or a senior talking to other seniors or a college student sitting in a dorm room telling other college students how great this product is that they use. If that's fake, if that's not authentic, it's not an actual human, people should know. And then they can make a determination if they are interested in that product or not.
Yeah.
So legislation is going to be big for us in addressing the issue of synthetics.
Excellent. Well, listen, guys, we're out of time. There's so much more, like we were saying. There's so much more we could discuss. But you guys are great, both of you. Jeffrey, really appreciate your expertise and just the way you laid it all out, because it was great. It was very understandable. Same, Avery. Same with you. Always enjoyed discussing with you. And these are highly complex topics that are evolving in real time. And these are two of the foremost experts who know them. So follow these guys, and I'll continue to write about them too in my The Brain newsletter. And thanks.
Thank you, Peter.
Good to see you guys.
Good to see you, Jeff.